order we see no reason to fear. However, we take note of our earlier 2023 in SLP. So it's 40832 of 2022, page 161, requesting the High Court to consider the request for early hearing. In that view, we request the High Court to take note of the same and dispose of the matter as expeditiously as possible.
Or in case the matter can't be, then CM 2129 of 23 may be decided.
As mentioned, main matter cannot be taken up for disposal. The High Court may also consider as to whether the application pending could be disposed of.
Application filed by the state government. But there's a larger issue which is pending before your lordships, but in petition 1397 of 2020. This is a slightly narrower issue pertaining to the compulsory.
Tag it along. Yes. Notice tag along with WPC number 1397 of 2020.
Lordships have issued notice. Yes. Deeply well. Well, I believe that is coming up shortly. Well, 11.2 talks about the establishment in question first charge. Here, admittedly, the one that I have purchased the loan from UCO Bank is a different establishment. The directors in the other one, which is in default of the Provident Fund, were also partners in this firm. It's an 11.2 recovery notice which is
29, not which
11.2 clearly says that in case the establishment doesn't pay and the promoter doesn't pay, the first charge.
सभी लोग लाइक करते रहिए भाई, सभी लोग इसको लोग देखना लाइक करिए.
Not on the promoter. Here what is happening is that
कमेंट करिए कमेंट.
I purchased it from UCO. We ultimately under SurfAC sold it. UCO initiated proceedings under SurfAC. We sold it. After the money came in, they came and said that we want a part of this pie.
Correct. But what is due and payable there is the employee's provident.
Right, but my lords, today I am a secured creditor under SurfAC. It has a non-abstante clause in 26C. It says that notwithstanding any provision contained anywhere, and it's a later statute.
The employee's dues will take.
My lords, may I with respect, but someone will have to decide that. Please see 11.2. 11.2 talks about first charge on the establishment, not on the promoters. That's the clear wording of 11.2. My lords, we'll have to be ultimately guided by what the statute says. Now, two things are clear here. For a statute, it's a later statute than the Provident Fund Act, and after that, my lords, the provision which is relied on of the Provident Fund Act is 11.2 for the purpose. In 11.2, kindly see the wording of 11.2. I need to show three provisions to your lordships. Kindly first have 26C of the SurfAC Act. Just has that for a minute.
आवाज बंद हो गया है.
अपूर्व माइक खोल दो.
From UCO Bank. After that, assets are sold under the SurfAC Act. It's not that money is owed by me. I purchase the asset, then asset is auctioned as SurfAC permits me to do. And I realize what I have purchased as an asset reconstruction company.
You take as assignment as.
No, my lords, may I with respect say, please see three provisions and I leave it at that. Just have three provisions. Kindly first have 26C of the Securitization and Reconstruction Act, SurfAC. For a minute, my lords, 26C. 26? Capital E.
Priority to secure.
Yes. My lords, priority priority to secured creditors, notwithstanding anything contained in any other law for the time being in force. After the registration of the security interest, the debts due to any secured creditor shall be paid in priority over all other debts and all revenues, taxes, cesses, and other rates payable to the central government and state governments or local authority. Now,
Fund Act also must be with
Manas, I just need to show. Provisions of this Act shall effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect of such law. And not be state of the which the note issue of the provisions of the subsection from a contribution data employees punishment is not Rajesh engineering whose loan is high tech which owed the money to the workers. So today what is being done is the very
mortgage for that loan.
No, my lords, this was mortgaged to us under the Act. Under Bpsc, it was mortgaged to us.
Mortgage to that loan, and therefore those dues are now being short.
No, my lords. What is being short is that the loan is
deposit 50%.
My lords, may I with respect say, ultimately we'll do whatever your lordship says, but may I only attempt to say this. My lords, I am a legitimate purchaser under the SURFACE Act, which I am entitled to. The SURFACE Act recognizes that I can purchase a loan. I have purchased the loan. The loan has been purchased from an establishment which does not owe any penny to it. The only commonality sought to be drawn is that these were also directors in other firm, which owes Provident Fund dues to its work. Now today, my lords, 11.2 I have straight away shown to your lordships to say that the first charge can only be on the establishment. The establishment is high-tech. The establishment is not Rajesh Engineering where I purchased the loan. So if I purchased the loan from Rajesh Engineering, the promoters for that gave a security therein, my lords. How does 11.2 come in? 11.2 is for the establishment. The PF dues are not from Rajesh. The PF dues are from the other company, my lords. The PF dues are not from Rajesh Engineering.
50%. Sure.
My lords, may I only say one thing, and I leave it at that. Would your lordships be kind enough? Something slightly lesser than 50%. Because I'm not the defaulter of the loan.
9.5%.
My lords, may I only would your lordships say 30-35%? And lordships, these are difficult times in these matters. Make it 30 to 35. 50%.
Since the matter requires examination, issue notice to the respondent. In the meanwhile, there shall be interim stay of further proceedings of recovery against the petitioners, subject to the petitioners deposit 50% of the demanded amount with the Provident Fund.
Very good. Very good.
High Court plus quash the termination as well as blacklisting order after giving a finding that the show cause itself suffers from infirmity. Please see page 5, Milaks.
See, after this you can go back to the
The question is
after this replying to the show cause, please send it.
Please see there is a finding of the tribunal which is affirmed by the High Court of Supreme. First see page 5, page 5 last paragraph. But usually blacklisting like show cause notice dated 27th of March is that does not reveal specific material information that there was a proposal to blacklist the petitioner for a period of 10 years. In other words, proposal is required given for number of years of blacklisting a person.
So that would be a ground.
Let's please see one thing.
No cause notice can only be challenged on 2 grounds, you know very well. Only for lack of or valid right. Now it says I could reason is flawed. But anyway, ultimately, justice was done to start from the start. Do that. In fact, before this court, we would have stayed the order. So be happy with the order.
Just one second. I understand. Just one second. There is a finding of the tribunal which is affirmed by the High Court stating that there is no fundamental